Good morning, Your Honors. May it please the Court, I think that the place where best to begin is by saying directly what this case is and what it is not, because there seems to be some disagreement between the parties. This is an equitable action seeking medical surveillance. It's no more and it's no less than that.
Excuse me, Mr. Phillips.
Yeah.
It's seeking medical surveillance for a particular purpose, correct? Namely, the detection of lung cancer.
That's absolutely correct, Your Honor.
Should you be addressing your pleas to the legislature?
Your Honor, that would be a place where the plea could be addressed, but there's no reason the common law certainly traditionally has accepted tort claims seeking equitable remedies. And so we come to the court to seek this remedy because, frankly, that's traditionally.
Isn't this a case that really requires a lot of legislative fact determinations that we're unable to make? We don't have people to investigate. We don't have staff to investigate, and that isn't really our bailiwick.
Your Honor, I think that the court has fact-finding powers that in some ways are as good as the legislature's with respect to specific cases and controversies. And what we are not seeking here is a public policy determination that this form of surveillance should be available generally, that public dollars should be spent for it, that it should be mandated, that insurance companies should be forced. All of those things certainly would belong in front of a legislature.
Could I ask you, though, I mean, you are seeking equitable relief. Nowhere in anybody's papers does the fact that smoking is certainly to some degree a voluntary activity gets mentioned. Doesn't that play into the equities of this? I mean, your clients choose to keep smoking. I mean, we can talk about addiction, but you don't talk about that either. I mean,
well, Your Honor, I think that the answer to that is that the law certainly could contemplate in appropriate cases affirmative defenses and the like. And that would be something, again, that courts are well suited to address. This court has already, in the Hagelin case, considered this very question. And as I read Hagelin, except under the most extraordinary circumstances, which would not here apply, which would be somebody who started smoking at a time that they were already faced with a disease.
Well, no, this is an equitable case. It's not a tort case. And doesn't the principle of clean hands apply? Your clients are coming and asking for equitable relief, and they're still smoking.
Your Honor, the answer to that is that, again, in an equitable context, what I would suggest to that is, as I understand the doctrine of clean hands, that would pertain in a situation where an individual acted at the get-go with a deliberate disregard for the safety and disregard.
They haven't been warned?
Excuse me?
Your clients haven't been warned?
My clients, again, with respect to that, there were warnings, but they also have a situation where they're dealing with addiction. The reason that addiction was not mentioned, in fairness, is that we don't, for Rule 23 reasons, and Rule 23 reasons only, we were proceeding on a different theory that has nothing to do with whether or not the case is cognizable. If the addiction issue somehow factored into this court's thinking, then we, would replete it and deal with the Rule 23 context.
Let me ask you another question. I know you say this is an equitable case, but absent the increased risk of lung cancer due to exposure to this cigarette smoke, are the physical injuries that you describe in your complaint?
Yes.
The federal court calls them subclinical physical injuries, but I don't know really what that means. There are a bunch of things that you describe. Are they sufficient to support ordinary personal injury damages?
Your Honor, that's an interesting question. It seems to me that the answer would be yes. What the measure of damages might be raises a different question. In other words, if I'm short of breath or have a cough, or my circulation is poor, as is the case, I think that would create a cognizable claim that would be addressable in money damages.
So why aren't you
Mr.
suing for pain and suffering and future medicals and all the traditional tort kinds of damages? Why should we have to have 2 lawsuits as opposed to 1?
Your Honor, the answer to that, again, is a pragmatic one, but also one that's grounded in simple justice. To take on the tobacco company over a cough is simply not a pragmatic or sensible thing.
Excuse me, Mr. Phillips, but that really goes to class actions. I mean, you could take on lots of plaintiffs with lots of costs, but that's a different issue. Could I ask what I think is similar to Justice Cordy's question, but with a slight reformulation? I asked whether the relief here was monitoring for the detection of lung cancer, and your answer was yes. Yeah. If I go to Justice Breyer's formulation in Metro North, have your clients either the disease or the symptoms of lung cancer?
The answer to that is no. If they
Isn't that one way that the court, at least the United States Supreme Court, on monitoring, has attempted to carve out, as it were, a zone where there could be, because the court did not preclude, as I understand it, monitoring, but where, depending on what the monitoring is, I realize it may be counterintuitive because among your clients there may be people who will develop lung cancer, but to cabin it in some way, I think the court was saying, and we can reach a different result, that you have to have a disease, disease or symptom.
Well, Your Honor, I'd like to sort of parse what I think disease and symptom mean. An individual who has lung cancer and can demonstrate it does not need surveillance. They need therapy, surgery, whatever treatment is. So by definition, a surveillance claim, and certainly the Supreme Court was recognizing that there could be surveillance claim, as a logical matter can't exist for people who already can demonstrate to a court in some fashion that they have the disease. That begs the question of whether they have harm or demonstrable harm. And there's a kind of disconnect when you try to move from some quantum of harm to the disease in question.
Well, you're moving from some quantum of harm to the specific relief for which you're looking at. And the judge, the federal district court judge, made quite specific findings alluded to by Justice Cordy about the breakdown of a cellular structure. Because of modern technology, we now have, the enormous capacity to detect whether there has been a breakdown of this, that, or the other. But it is linking that harm to the relief that is being sought.
Well, Your Honor, every expert on either side of this case, and there's nothing controversial, I think, in the notion that 20-pack-year history of cigarette smoking in an individual over 50 creates the risk of lung cancer. And the virtual certainty, as I think one of Your Honors indicated, that some of these class members surely are percolating lung cancers.
May I just follow up on that then? Assuming we were to agree with you, how long would this medical surveillance be required? Would it be for the lives of all of the plaintiffs?
Your Honor, I think that that would be the case with the following caveat. In a medical,
so it might go 20 years.
I think that
more?
I think that that's correct. I think that you would be talking about the creation of a trust and the funding of a trust that would proceed over the course of roughly 20 years or more to provide this very discrete procedure to
for people who you would say might have symptoms but not the disease.
No, they don't even have
They,
symptoms.
Your Honor, they would have symptoms of cigarette smoking which might or might not be related to the disease. So that,
And which might never develop into lung cancer.
correct, the remedy that they're seeking, because bear in mind, these folks aren't asking for money. What they're asking for is the opportunity to save their lives.
But the cost, I take it, if just the Oregon is any indication, that's $29 billion, right? Is that?
Oh, Your Honor, I can't speak to how Oregon
Well, that was what was in the opinion.
Yeah, I can tell you that the expert proofs were that it would be measured probably in 30 or 40 million a year times 20 years is about, it's not an inconsiderable sum of money, but it's certainly not 29 billion.
Mr. Phil, I'm quite sure that I'm going to sound very repetitive to you, but I want to focus on where the real dispute is because of all the back and forth on the SIR reply briefs and counters and so on. Your claim in your brief is that they don't presently allege, your clients, any manifest smoking-related disease. And it is clear from the judge's factual recitation that there is some injury to the lungs, right? And again, I think it's the linkage between the disease, and as I understand it, they don't have the disease and they are symptom-free of lung cancer. Is that correct?
They are symptom-free of lung cancer, and let me parse that
Right.
clearly. A person who is short of breath or has a cough
Has clearly been injured and may have been injured by the smoking of cigarettes for 20, packs a year or whatever it is.
Yes.
20, yeah.
And shortness of breath or coughs could be symptoms of lung cancer.
Certainly.
However, they are of such a diffuse nature that no doctor can say, oh, you're coughing, therefore you have lung cancer, nor will doctors, because someone presents with a cough, immediately say, well, we have to open up your chest.
I take it that there are mechanisms, again, in our more sophisticated medical world, to detect whether somebody has a symptom of cancer such that treatment will be required.
Yes, Your Honor, if somebody is coughing up blood or there are clear signs that would motivate a clinician to say, look, we need to take very drastic steps here to rule in or rule out lung cancer, and that would normally involve surgery, biopsies, and so on. The point is that typically when that occurs, it's too late. 85% of people die.
I
so
understand
that's-
that. I, for one, am never persuaded by a parade of horribles, but I think what gives me, at least, and many judges, some comfort is to say, where's the outer limit? Now, in the many of the cases are employment cases, and they are slightly different, but essentially you have a manufacturer here. Query whether the manufacturer owes any duty of any kind to anybody, but that's a different issue. Where is the outer limit that you would draw? So that, for example, if if there's hazardous waste disposal, if there's, if you have a house next to a highway, I mean, give me the outer limit of where somebody could come in and say, I need monitoring.
Your Honor, if I could just invert it for a second, what I would say to you is this. Where the outer limit lies requires a different record that's before you. What we have is the minimal. This is the inner limit. It seems to me, and this is the point that we're making, here we have a wrong that's inflicted a harm. The doctors say that this is a necessary and required step. And in a traditional tort analysis, let me put it this way. Imagine a fellow who's in an auto accident and breaks his leg. and the doctor treats the broken leg and then says, in addition to that, you should get x-rays every 3 years because you might get arthritis. The x-rays will cost, $50 a year. I doubt that any court would have any difficulty in that case ordering or awarding that, which is in effect surveillance. It's diagnostic care.
So what would the standard be in order to award those sort of future medical damages?
Your Honor, wrongful conduct that proximately causes a harm
Right?
that a physician, qualified clinician, says would reasonably require, as a consequence of that wrong, this future care. And that, to me, is a classic tort analysis, and it's exactly what we have here.
But don't you then go back to Justice Spina's question to say, leaving aside the economics of the lawsuit, can you not sue for shortness of breath and then, as part of the relief, say this may lead to arthritis, lung cancer, and therefore you need an x-ray every 3 years?
The answer is you certainly could, but why do you have to? Why is a plaintiff required, as a tactical matter, to seek every element of damages that he or she might? I don't understand that that ought to be the law or is the law, so that where you have a plaintiff who, for, let's say,
But that is the law, isn't it? Don't you have to bring all your claims now?
the answer...
Arising out of that, the harm, arising out of the incident.
Yeah, but you're not required to. A plaintiff could
You
choose...
can waive it. You can waive those.
Could
That's what you're
waive
saying.
those claims, and these plaintiffs are not interested in asking a court or a jury to award them money for a cough. They're interested in something that to them is vastly more important, which is the surveillance that might save their lives. So I don't disagree that you couldn't seek that relief, but why would we have to? Why would that be required? And I'd also make the observation that with respect to claims, you must bring your claims now for all claims that presently exist. If you had disease A today and 5 years later developed a completely different disease as a result of the same exposure, it seems to me you probably would be able to bring that claim in the future. But I'm not sure that's directly germane to what we're dealing with, except for statute of limitations accrual purposes.
Thank you, Mr. Phillips.
Thank you, Your Honor.
Ms. Birnbaum? Good morning.
Good morning. May it please the court, my name is Sheila Birnbaum. I'm appearing for defendant Philip Morris. Justice Marshall, you asked a question, what are the limits? Well, I think Justice Breyer and Buckley put it correctly, and that is, this is limitless liability. It's unlimited, it's unpredictable, and it goes on, Justice Ireland, for the life of these plaintiffs. And we're talking here, at this moment, of 60,000 people.
Okay, well, let me stop you for a moment. Let's imagine a slightly different scenario. Let's imagine that I work in a factory and am exposed to the negligence of my employer to certain fumes which now mean that I have severe coughing, shortness of breath, potentially emphysema. I had been an athlete. My life has been diminished by it. Would you say that I had a cause of action against that employer with regard to the injury caused by those fumes?
Well, first of all, there's workers' comp, but taking away from that,
Put aside the workers' comp issue.
if you had a claim, the answer to that would be if you had objective symptoms and injury, illness, you can recover under traditional law of Massachusetts tort law all of the damages that flow
Okay,
from that injury.
and would it also be that among those damages that it may be a reasonable medical expense if it turns out that those fumes now have markedly increased my risk for cancer, that that my doctor may arguably consider to be a reasonable medical expense to have me surveilled every year or two in order to determine whether or not I should be detected early for that cancer?
It may be if there is an illness or disease That's where the court
When you say illness or
draws the line.
disease, is shortness of breath, is the fact that I used to be able to run a mile in 8 minutes and now can't run it for at all? Does that,
Your
would
Honor,
that not be
I'm
sufficient?
not sure that shortness of breath in and of itself would be sufficient. But here we don't even have shortness of breath. The question presented to you by Judge Gertner in the district court talks about subclinical effects. This is not a manifest injury. There are no symptoms here. There are no symptoms alleged. There were no symptoms proved. There is no illness or disease. Courts have drawn lines for very good reasons, because they want to avoid the unlimited, unpredictable liability which the Supreme Court referenced in Buckley. And it's no
But Buckley is a case, I know it's federal law, but it's also a case in which the claim was for negligent infliction of emotional distress. I mean, it related to that. And I know you argue that it's the same standard that should apply as to whether there's injury, but there are substantive differences between one and the other.
You're absolutely right, Your Honor, but Buckley had two claims, one for negligent infliction of emotional distress and one for medical monitoring. Similar to this, exposure to asbestos. These were the snowmen of Grand Central, had been covered with asbestos dust. They had exposure to asbestos, and they were seeking medical monitoring for the risk of cancer in the future. So it was directly in point there. And it's no surprise that 7 of the 8 Supreme Courts since Buckley that have looked at the issue of whether they should create a cause of action for medical monitoring have said no, based on public policy. And this is...
Can I just,
sorry.
forgive me for interrupting you.
No.
If you go back, I'm just looking at, I'm not either a microbiologist or my physician, so I read the statements contained in paragraphs 14 and 15, of Judge Gertner's facts that she certified to us. If she had had a paragraph 15A that said, because of the inflammatory reaction in the bronchi and the bronchioles and accumulation of inflammatory cells and secretions and there is shortness of breath such that it impairs, some serious physical activity. I'm trying to keep away from workers' comp. Would that be sufficient? I mean, is it the conclusion that this is an illness or disease?
I don't think shortness of breath is an illness or disease the way this court and other courts have looked at illness or disease. It has to be something concrete.
But it's
even-
harm. But it's concrete harm. It's real. It's measurable.
It may be, Your Honor.
Well,
but
let's just put aside whether shortness of breath is an illness. You're saying if paragraph 15A had said as a consequence of inflammatory reaction in the bronchi and bronchioles, as a consequence of that, the plaintiff has an illness of something or other, then we're in a different case.
A totally different case, and it's not the question, and you should decline to answer this question, because this question is not about objective illness.
So
not
we can
about
answer the question.
Yeah, you can answer no. This is
Yeah, I mean,
not,
that's an answer.
that's an answer we would like. But it's not, if they had emphysema, they could go back to the district court, and the court can decide whether emphysema is definitely an illness, and you should be able to recover for all your damages that flow from that illness. But if you would, I would like to talk about these public policy issues because they're quite important. And Mr. Phillips said, this is a small case. It doesn't talk about general public policy issues, but that's not so. The public policy issues here are enormously complex. The courts that have looked at this, the Lowe case, the Michigan Supreme Court, the Oregon Supreme Court, the Kentucky Supreme Court, have all said that the public policy reasons are important. And why? Let's take this case, for example. The plaintiffs would like to have low-dose CT scans. There is not one, and the plaintiffs agree with this, not one medical, scientific, governmental organization that recommends low-dose CT scanning to show lung cancer. In fact, there is a long-term study now being done by the NCI in which they are looking to determine in a real epidemiological, well-done study as to whether this diagnostic tool even helps lower mortality. We don't know that, so
Okay,
this
but
is totally
is that for us to decide? That seems to be a matter for Judge Gertner to decide if it goes back to her.
This is not for you to decide, Your Honor, as a matter of fact. But what it shows is the huge public policy issues and why courts have stayed away from getting into medical monitoring. Judge Breyer noticed this
Can
in
we
Buckley.
just leave Justice Breyer and just turn to Justice Ginsburg in the Third Circuit for a moment?
Yes.
Her articulation of when a plaintiff should be able to recover the costs of medical monitoring. So we enter the second part of the Breyer opinion. And if you read those, significant exposure to a proven hazardous substance. And then, as a proximate result, the plaintiff suffers a significantly increased risk of contracting a serious latent disease. That's where you depart from Justice Ginsburg?
No, Your Honor, I think the Supreme Court of the United States and the courts that have looked at it since then all say that if you have exposure, if you have even subclinical effects, because in most of these cases you have subclinical effects, that's what gives rise to the need for medical monitoring. That's what gives rise to your increased risk of harm. If you have that, it's insufficient. You have to...
Well, that's what I'm saying. It's that element of Justice Ginsburg's articulation of what she would say are the requirements for medical monitoring. That's where you part company. What has happened to the Gottschall line of cases?
But there's been no change since Buckley, Your Honor, and I think she was in the dissent there was a two-person dissent in Buckley, sure. And she was in the dissent and didn't carry the day there. And all the other Supreme Courts, except Missouri, that have looked at this in the last 10 years have all agreed that public policy should not put courts into determining these very complex medical issues.
Is it so clear, though, that Oregon would decide the same on the record in this case? I mean,
it's almost the same case, Your Honor. There was a 5-pack year. It's a cigarette case.
Yes, I know, but the opinion, at least, I haven't seen the record, but the opinion spends a lot of time talking about how there's no allegation of harm, that all that is alleged is an increased risk of cancer. That's different than this case.
There's no allegation of harm here, Your Honor. What is alleged is that there are subclinical changes in the body. That's not...
Well, the plaintiffs allege that cigarette smoke has caused them damage and injury to the tissues and structures of their lungs. Isn't that harm?
No, because it is not harm that courts would recognize, that they would provide a cause of action for. They would not be able to come into any court in Massachusetts and say, I have subcellular injury, I have subcellular effects.
I don't. These words are not helpful. Subclinical, subcellular. I'm not sure they're very helpful to me.
I think what I can try to draw the distinction, and I think what the courts have been looking at is they say if there's an illness, if there's an impairment, these are not impairments. They don't provide symptoms. You usually can't see them. The person doesn't know they have them unless they have a diagnosis.
This is part of the problem, because if in fact, taking Judge Gantz's example, if in fact the damage and injury to the tissues and structures of the lungs result in the fact that I can no longer run, which would be a huge blow to me personally, I would say that's really quite manifest to me. I am impaired. Why isn't that enough?
Well, it might be if the court could, if the experts could show that is a present injury with objective symptoms. But that's not what you have before you in this case. There are no objective symptoms. There is no present injury. No, Judge Gertner did not use the word subclinical injury even. She said it's an effect because that's exactly what it is. It is a change. And you know, all of us in our bodies have changes to the cells. Why? Because we're all exposed to toxic substance. Some people tortuously, some untortuously, but there are cell changes going on in our body.
Ms. Byrne, forgive me for
sorry,
interrupting.
Your
I
Honor.
want to go
No.
back to Justice Ginsburg. I know you don't agree with her formulation, but if I look at her, her elements for recovering the costs of medical monitoring, the plaintiff proves by expert evidence that he has been exposed to a proven hazardous substance through the negligent actions of your defendant. I'm not asking you to say that Philip Morris was negligent. And then, as a proximate result of exposure, the plaintiff suffers a significantly increased risk of contracting a serious latent disease. Assuming that one wanted to go with Justice Ginsburg's formulation, has that been pled in this case?
Yes, I think they have pled exposure, and they have pled an increased risk of harm. That's what this
Then
case.
she has a third one which says, by reason of the exposure, a reasonable physician would prescribe a monitoring regime different from the one that would have been prescribed in the absence. And I take it you're saying here they haven't met that test.
That's exactly right. And not only that, that test that she is talking about is not a test that most courts have adopted.
No, I
especially in the
understand
last
that.
10
I
years.
understand that. I was just trying
Yeah.
to understand that even if one went with that test, your previous statement about the low level, whatever it is,
Yeah.
monitoring, doesn't meet her test.
Yes.
Okay,
And
but
let
if-
me
but-
come
but
back.
if- But if
Sorry,
you're
Your
right, don't we answer yes, and then you argue to Judge Gertner that the third test that has simply not been met by the plaintiffs in this case?
No, because on this case, if you would say yes, then that would mean that you could have subclinical, you could just have exposure, and you could have effects, which everybody has from exposure to toxic substances. And if you think you have 60,000 potential plaintiffs, you will have millions of plaintiffs coming into this courtroom from every workplace, hospital.
But I don't get that. Why couldn't we say yes, provided they meet, say, the Paoli factors, or the Judge Ginsburg adoption of the Paoli factors, or the Redlands Soccer Club factors? Why couldn't we do that, and then you can argue to Judge Gertner that they failed to meet those factors?
Because, Your Honor, that just opens up the doors to all kinds of cases. It won't be only this case. It will be hundreds of cases for asbestos. Asbestos would come back to this court, to the courts of Massachusetts, all the plural plaque cases. How dare.
They're here, Ms. Birnbaum.
I'm sorry?
They are here.
It takes some time to come back up to you. But if you look at the issue of pleural plaque, that is an injury to the lungs. The asbestos fibers come into the lungs. Justice Cordy, they injure the lungs. You may have certain...
So does the gas from the highway that goes
Right,
past.
exactly.
Can I just ask you this? As you can understand, we answer only the question presented. We don't get around to all that other stuff. They can do all that stuff. There's nothing in the questions that I see that says that a court has to do the medical monitoring. I mean, all I have is, does the plaintiff suit for medical monitoring based on the subclinical effects of exposure to cigarette smoke and increased risk of lung cancer, state a claim or permit a remedy under Massachusetts state law? Why have I got to give you that? Either she can do it or she can send it to,
Well, there would have to be court supervision. In this particular case, it might be the federal court that would have to have ongoing supervision.
But that's
for
not
years
my
and
that's
years.
not my problem.
No,
That is
exactly.
the
Look,
relief
how-
that's-
She didn't ask me to do that. So all this thing about getting the courts involved.
But it would be other courts, because you just can't cabin this or just leave it cabined to just this. You would have asbestos cases again. You would have dioxin cases, PCB cases. I can go on, as the plaintiffs themselves recognized. This would be workplace injuries in your home, around your home, in hospitals. There's just no end.
Well,
Justice Breyer
has
had it
Pennsylvania
right.
suffered those parade of
Because
horribles?
nobody has extended it. It was, if you
Pennsylvania did.
No, if you look at Redland, there are no products liability cases coming out of that, because they had a specifically different situation. Here, you have a products liability case. Make note, this is about a design defect case. This is a law case. Mr. Phillips keeps talking about equity. What is his claim? Design defect. That is an action at law. What is his damages? He wants to fund something, but it's truly money damages. It's going to be a money damage at the end of the day. And the courts, like Lowe, where they were also confronted with a court-supervised program, all came to the same results, whether it's damages, whether it's equitable or not. They did not, for all the important policy reasons, radically change their tort law. That's what this would be, a radical change in tort law. And you also have to change the statute of limitations.
Well, we're not even going to get into the statute of limitations
hopefully
with
you
this
don't have to
red
answer
light
that
flashing away. Thank you, Ms. Birnbaum.
Thank you very much, Aaron.